I want to turn our attention now to judicial lawmaking in the Human Rights Act. Now, the Human Rights Act effectively requires that the judges develop the common law consistently with principles of European human rights law. This leads us to a lot of problematic issues that are very much alive in the modern law. I haven't got time to go into them or really to look in detail at the relationship between the European Court of Human Rights and the Supreme Court in the United Kingdom. What I want to do is just touch upon then this theme of judicial lawmaking in the wake of the Human Rights Act. I want to look at really a couple of key authorities and just to elaborate the main themes. First authority, first case I want to look at is called Venables and Thompson and the News Group newspapers. It's a case from 2001. And I want to read you just a short extract from this case. So here's a quote from Venables and Thompson. Quote, "The European Convention of Human Rights applied in this case via the obligation on the courts in the Human Rights Act, even though the defendant newspaper were not a public authority and the dispute was one between private parties. The claimant's rights under Articles 2, 3 and 8 of the Convention were at risk and had to be balanced against Article 10. Let me explain what the court is doing in this quotation here. It's an argument about the application of the Human Rights Act. Now, the Human Rights Act applies only to public authorities. In other words, it would allow an individual to sue a public authority if that individual's rights have been breached by that public authority. The rights in question are, of course, the Convention rights that have been domesticated by the Human Rights Act. What the judges did in Venables and Thompson, however, and I'm sure you can probably guess this from the title of the case, is they applied the law to a private party, in other words, a News Group Newspapers Limited, in other words, a company, if you like, a company that publishes newspapers, not, in other words, a public authority, perhaps in first regard at what the idea of a public authority might be, i.e. the state or part of the state. So the judges are being very creative in this case. They are arguing that the Human Rights Act in certain circumstances creates rights against a private body, here clearly a newspaper or a newspaper publisher. What the court is also saying, if you like, is a balancing argument. Note that the claimant's rights under Articles 2, 3 and 8 of the Convention were at risk and had to be balanced against Article 10. In other words, Article 10 is the freedom of speech. In other words, the newspaper's claims that its human rights were protected under Article 10 had to be balanced against the claimant's claims, which used different articles of the Convention. I'm going to be talking about the articles of the Convention later on, so I'm not going to go into detail on Articles 2, 3 and 8, other than to say that Article 8 relates to privacy. So what the court here is doing is balancing the privacy of one party against the right claimed by another party to be able to publish information about that party. In other words, again, to pick up a point I made somewhat earlier on, what the judges are doing here under the Human Rights Act is developing a law of privacy. A law of privacy which limits the newspaper's ability to do certain things, to publish certain information, which is why, in the end, powerful newspaper publishers don't like the Human Rights Act because it prevents them making money by publishing salacious gossip and other irrelevant things that invade people's privacy. Douglas and Hello, case from 2001, makes a very similar point. I just want to read a short extract from Lord Justice Sedley, who was presiding in this case. Quote, "The reasons are twofold. The reasons that Lord Justice Sedley is referring to here are the reasons why the judges should develop a law of privacy based on Article 8 of the Convention. In other words, we're talking about the development of common law principles that make use of human rights arguments. So Lord Justice Sedley says the reasons are twofold, the reasons for developing the common law in this area of privacy. The reasons are twofold. First, equity and the common law are today in a position to respond to an increasingly invasive social environment by affirming that everybody has a right to some private space. Secondly, and in any event, Human Rights Act 1998 requires the courts of this country to give appropriate effect to the right to respect for private and family life as set out in Article 8 of the European Convention on Human Rights and Fundamental Freedoms. We can see there then that Lord Justice Sedley is making a general argument why the common law and equity should respond to human rights and develop protection of privacy within English law. Given recent newspaper stories around people whose privacy has been invaded by the papers with fatal consequences, I think Lord Justice Sedley's arguments are incredibly well made here. Those points then touch upon the judge's sense that in certain areas of the common law it is necessary to take human rights principles via the domesticated articles of the Convention and use those principles to develop protection of rights in areas where the common law might traditionally have been lacking, in other words, in relation to the area of privacy.